Welcome to Family Law and More, and this episode, which is about transparency and where we are. My name is Lisa Edmonds.
And my name is Claudia Saxton.
And today we are joined by Louise Tickle. Louise is an award-winning journalist who specialises in reporting on domestic abuse, family court and child protection. And we are fortunate that this is the second time that Louise has joined us on our podcast. You can listen to our podcast with Louise by following the link in our show notes. But since Louise was last with us, she has been very busy, firstly continuing the rollout and the promotion of the Transparency pilot, as well as making her debut appearance in the Court of Appeal earlier this year. And that may be the best place to start. So welcome, first of all, Louise, and thank you for joining us.
Thank you for having me on.
So can I start with your Court of Appeal appearance? First of all, how did you find it as a non-lawyer, as a journalist who maybe felt as though you had a bit of a target on your back at one point? How was the whole experience?
Gosh, there were so many feelings. It had been such a huge amount of work to get to that point. Deciding to appeal at all is a big decision. Or, we had to ask for permission to appeal. And then I can talk about the fallout from that if you like, very happy to. But, getting funding for it, it's not free. So we had to make the decision very quickly. Hannah Summers, my fellow journalist, and I, we had to get funding for it. We had to work incredibly fast over a weekend. We then had to work over Christmas. We acted as our own solicitors, which I can tell you was a big job because the Court of Appeal is not light on deadlines. And we had to make sure that we got everything right so that we weren't then criticised for that or that we didn't delay things because of that. Turning up on the day, we thought we would win.
Okay.
And you can never tell. But the decision that had been made by Mr. Justice Williams had seemed so extraordinary and outrageous to us. The decision that he had made to ban the media from reporting the names of judges in the Sara Sharif case was so extraordinary. And the terms in which his eventual judgment, when it was produced, was couched were way out. They were so bizarre.
It makes uncomfortable reading, if I'm honest, in terms of being part of the family justice system and you want to be, therefore, part of a body that has a good reputation, one that can withstand proper scrutiny and be accountable. So when you get the sound bites of what this judge was saying, given his caliber, level of status within our system, it was disappointing for me. I mean, and it must have been awful for you hearing and reading some of his personal views seeping into what was a critical decision for the country, really, given the very sad circumstances in which this litigation was developing from.
I mean, being compared to Andy Coulson, who was jailed, tabloid editor who was jailed for having, behaved appallingly, was a shock, I have to say. I think it was the very personal criticism of Hannah and I, and in fact the media generally, that really kind of jet-fueled our need to appeal. It stopped almost being a decision at that point, because what we knew was that if that was allowed to stand, every time Hannah and I and potentially other journalists turned up in a family court asking for permission to report things that were restricted, we knew, because, it's not easy being in court and barristers aren't always lovely to us, that those comments would come back to bite us. We would be branded as irresponsible journalists who did inaccurate, unfair reporting. And it would be used, I am absolutely certain it would have been used liberally, and it would have been very difficult to fight back against. When in fact, the only thing that I think he could point to in the Sara Sharif reporting was that when we had asked Mr. Justice Williams for permission to appeal, he had replied not giving it to us, but adjourning that off to some unspecified future date. And we had reported that he'd refused us permission. I mean, to us, it was a functional refusal because it was an urgent matter. To him, obviously, it was some terrible misreporting. And I don't think that this isn't in the judgment, but I had been in his court for, approaching a year, I think, at one point, in and out, on a case that I had reported for the Channel 4 Dispatches programme it was called Torn Apart.
Yes.
In a case where I had tried very hard to persuade him to allow me to report the facts of a particular case. It related to a woman whose name I can say because he put it in the public domain, Ellie Yarrow-Sanders, who had left the country with her son to escape her ex-partner. And he didn't allow me to report the details of that case. And so all we could report of that case was what we were allowed, which was very minimal. And it felt to me like I was being branded as having done unfair, unbalanced reporting on the basis of that. And I was like, well, hang on. I have tried my hardest. We've spent a lot of money, huge amounts of our resource, coming to court for hearing after hearing after hearing. We can report is lawful because you wouldn't allow us to report anything else. And now you're saying I'm unfair and unbalanced. So yeah, I was furious.
I can imagine. But it sounds as though your gut instinct very much was this decision is wrong on a number of levels, that it can't stand and you need to do something about it. But you then had another battle on your hands. How do you make that happen with reference to representation, resources, the quick turnaround, getting your head around the paperwork and all those administrative steps that you need to go through? But I think what I can say is I watched the hearing in the Court of Appeal. It went on for about a day and a half. And again, part of transparency, it was on a live stream via YouTube. And it was gripping. It really was, because it engaged in very important matters, not least about the social media aspect that exists now as compared to maybe some of the earlier decisions that were referenced. And we'll chat about that in a moment. But I think what's fair to say is you then did marshal a good team around you. And you were, if I can say, I thought excellently represented.
Well, Chris Barnes had represented us all the way through, and he had done it pro bono. We managed to get funding from Tortoise Media for the permission to appeal stage, and managed to get funding from a strategic litigation organisation, Law for Change, to pay for his expertise at the Court of Appeal stage, the actual hearing. But Chris was deeply embedded in the case. And I think I can't imagine turning up to the Court of Appeal, on one's own without that level of expertise. And yeah, I thought he did a fabulous job. Until the judgment itself was published, Mr. Justice Williams was effectively instructed while on holiday to get it written and send it in. I don't think it had been quite such an immediately obvious win. The central issue that we were appealing was the fact that we were not allowed to name the judges who had made critical decisions in terms of the care of Sara Sharif. And, one in particular who had presided over all three sets of proceedings substantively.
Yes.
In principle, we wanted to be able to name them all, but the other two were, they had made appropriate orders and single orders. So yeah, we were lucky. And although we were pretty sure we'd win, you still arrive in the Pret opposite, the Royal Courts on the morning with butterflies in your tummy, and it's a big deal. We sat there, Hannah and I, and we kind of looked. We were in court 4, the biggest court, because, the press bench was full. There were all these silks and barristers.
In the wigs and gowns.
All in the wigs
and bit.
And you kind of have to shake yourself and sort of go, gosh, we made this happen.
Yeah.
We, in fact, were the only 2 people unpaid in that room that day because we were not funded. Sorry, I should say that Irfan Sharif and Bainash Batul's silks were acting pro bono.
Okay.
I'm not quite sure why, but anyway, it was a big deal.
Well, and I think it's definitely going to be case of the year at some awards, I would have thought, for 2025, and it definitely goes down in the history books. What did you think of it, Claudia?
One thing I took away from the judgment was that debate between the naming of the judges and, of course, because of, like you said, the social media impact that case has had and the public scrutiny, the risk that it would have potentially to the judges being named, and, of course, their Article 8 rights and their right to a private life, and that debate that the judge had in the appeal of the potential risk to their security, and how he resolved that of, well, judges know upon taking that role of public office that they are going to be scrutinised, and they know that upon making judgments that they are subject to that scrutiny. What did you take away from that, Louise, as to the potential security risk of the judges being named?
Look, there are the judges in criminal courts who send people down, or, dangerous criminals with associates, gangs, family members who can become very indignant, who send them down for very long stretches.
Yeah.
It is a function of being a judge that you make those decisions, you're entrusted with those decisions, and you have that responsibility. Any professional in any walk of life has very serious responsibilities towards society. And it is simply something that comes with the job. I mean, I would add that had Mr. Justice Williams not banned their names from being published, I suspect it would have been, certainly for the two who had made the single protective orders, a sideshow, that they probably wouldn't even have had their names published at all, frankly, because why did it matter? For Her Honour Judge Alison Rayside, yes, she may have been criticised. I've criticised plenty of judges in my time, and they haven't been targeted. But all the same, even if they were worried, there are responsibilities that employers have towards their employees to put measures in place, potentially to protect them. And time was given for that to happen. And I would also point out, and I think it's important too, that none of the judges themselves had made any application for anonymity. So this wasn't something that happened at their behest.
Can I maybe look at it from a slightly different angle? So rather than looking at sort of personal safety and security, more about how these judges move on to their next case, and they've got to engage with a new set of professionals, certainly a new family. And families, parents in particular, will be able to Google now, for example, Her Honour Judge Alison Rayside, and find commentary about her. And does that then have an impact on the next family being able to engage in the process she sets for that case, to trust her judgment, to buy into it? So, for example, I was looking last night and I went on some forums and people had posted, she should be suspended. Who would want this patronising paper shuffler on their custody case? She absolutely effed up, and I'm sure she regrets it every day. I couldn't read it all. This person needs to explain herself, and then she needs to rot in hell. So if I was representing a parent going in front of this particular judge and they were saying to me, well, I don't want this judge presiding over my case and making decisions because look at what sort of Joe Bloggs has been saying about her. Do you think that is a relevant consideration in the purpose of naming judges?
Well, that's what accountability means. That we are able to scrutinise, that the people to whom the scrutiny matters, i.e. the families who you represent, will know more about the people who are making decisions about their lives. And presumably, if you're representing them, will be able to have their views expressed. Whether their views will have an effect is very doubtful in the case of the judge's appointment. But I can't see how people, let's leave aside the heightened language.
Yes.
But the sentiment behind it, I don't see why that wouldn't necessarily be seen as something perfectly justifiable for somebody to raise.
And then what about sort of recruitment and retention of good quality judges? Do you think over time it could have a consequence of individuals saying, I don't want to be a judge because I don't want that level of accountability, i.e. where members of my own family, my own children can put my name in the Google search engine and see all these people saying all these quite unkind, cruel things about me. Do you think
that's what living in a democracy means? It means that we can scrutinise and criticise, and that there are results as a result of that scrutiny. It's not that you scrutinise and have the ability to criticise in order that nothing happens. If something happens, which means that there are fewer judges, then ultimately the system will have to look at itself. Judges might have to look at, these are all kind of very simplistic kind of cause and effects that I'm kind of giving. But ultimately, if you couldn't criticize a judge, you'd be living in a totalitarian state.
Okay.
And speaking of accountability and the judges being named, of course, the tragic case of Sara Sharif, and they weren't named at the time. Do you think going forward with more accountability and scrutiny of judges that hopefully cases like that might be able to be prevented at some level? Of course, in that case, there were multiple failings and we're not sure exactly yet, but going forward with more transparency and accountability, do you think that's a step in the right direction?
These things are only ever small increments towards progress. There's never a grand naming that will create an incontrovertible change for future families. So I never claim that. I think we should remember that judges being named is completely normal. It's a fundamental principle that's actually, I don't think has ever been questioned until now. I've never come across it and nobody alerted me to it. So I don't think naming judges is suddenly going to necessarily make judges make different decisions at all. I think these are all just small building blocks in keeping a system honest.
So is it fair that this decision, the Court of Appeal decision, has given you a bit of momentum around your drive for greater transparency? Do you feel that more people now know about what you're looking to do and how you're looking to make positive contributions around the decision-making that happens in the family courts?
I think it's definitely raised the profile. Yeah. Things like the reporting pilot. I think it's made journalists sit up and take notice, and the media generally, in the importance of these cases and the incredibly, life-changing decisions that are made for children. So yes, and I think it's set a really important kind of marker in the sand. It's like this far and no further. There are things which judges shouldn't do, and anonymizing fellow judges is one of them. And it created a lot of conversation about accountability in the family justice system, which I think was really healthy and really useful. I mean, in terms of this particular case, I am now going to be looking much more deeply at the processes that took place between about 2010 in the Sharif family and when Sara died, and until 2019 when the final order in the private law proceedings was made, which, how would you say, it sort of regularised the fact that she was by then living with her father, having in fact chosen to go back there. So
how do you do that? Do you have access then to all of the documents? Okay.
Yes, we have that was what Hannah and I were fighting for.
Yeah.
Complete disclosure. And we got, I don't think there's anything that we wanted that we didn't get.
And as you engage in that process, are you able to access professionals that were involved at the time and interview them?
Be interesting, wouldn't it?
Yeah.
Well, in the final set of proceedings, there were no professionals.
Okay.
Just Olga Doman, Olga's mother, Arfan Sharif, her father, and Bainash Batul, her relatively new stepmother. And it's very evident from the transcript of that hearing, which is so telling, and which I will be hoping to recreate elements of. I'm sort of shaking my head because it's such a kind of desperately naive and optimistic way of looking at a man who this judge knew, although there had never been a fact finding, which in itself was problematic, was highly abusive, and not just abusive towards women, but also abusive towards children. So we don't have the transcripts of the previous care proceedings, and obviously there would have been professionals for those. I would love to. Whether anybody would be willing to talk to me about it is another question. I find people really nervous and really anxious about that. I mean, I don't know how you would feel had you been involved in that case and a journalist came up to you and said, can you tell me about how you felt the judge managed the proceedings in 2013 and 2015? How would you feel?
I'm going to go no comment on that question. I only ask because I think with the drive around transparency, it's also giving other people that engage in the family justice system maybe a bit more confidence about wanting to speak out, to be heard, to tell their story if they've had a poor experience and want to do something to improve the process so someone else doesn't go through it. And I think there are sort of pending applications before the courts where judges now are having to consider whether a party directly involved in proceedings has the ability to tell their story through the forum of journalism. Is that something that you think absolutely should be allowed and it's as simple as that? Or do you think it's more nuanced and sort of fact dependent?
Certainly for individuals rather than the lawyers who represent them, that's something that people are truly desperate to do and have been all the way through it is over a decade now since I first turned up at Bristol Family Court, really not having a clue what I was getting into. I have a separate inbox, separate email address, which is my only public email address now. And it receives, up to 5 or 6 emails a day, every day. Day in, day out from people who want to tell me about their family court case. So that's one side of it. Whether they should be able to, well, that's interesting because if they had a family court case happening now and I was proposing to go to a hearing, they would presumptively be able to talk to me because once a transparency order is made, retrospective permission is given for somebody to talk about their case. That's much, I don't think that is really quite the case for previous cases.
Yes.
And I'm in the course of an application now to be able to report on. In fact, I now have permission to speak to the parties involved who want to speak to me. The next stage, and I have the judgments, or 2 of the important judgments, but what I want is disclosure as in Sara Sharif with the papers. And, I'm not pretending that this isn't a relatively onerous thing for the family justice system thing to have to engage with. It's taking up a circuit judge's time. When you have powers, when the state exerts powers over people's lives, and there is a process whereby they are potentially able to talk about that, then I think they're going to do it because these are life-changing decisions, and I think it's entirely justifiable. And I think it's again one of those, if the state exerts power, then it has to give people an opportunity to comment.
Okay.
And up until that family justice system, they have not even been allowed to speak.
That definitely sounds as though there are more developments on the horizon. So we will keep a close eye on those. And then just going back to the pilot, how is that going? Have you landed where you hoped you would land with that?
So it does everything I was hoping for. It still doesn't mean that you can kind of willy-nilly go and write anything you want. It gives you much more of an opportunity to investigate, but there are still processes you have to go through. It's not easy still, it's easier. And the experience, particularly of other journalists who I've been in touch with recently, show that judges are on board.
Okay.
Or at least if they're not on board, they seem to be on board. And in fact, do you know what? I have pretty much always found that I have rarely, very rarely come across a judge who has not. Some of them champion openness. Some of them actively protect it and want you to be able to do what you can safely. Others, I think, tolerate it and understand intellectually the reasons why it matters. It's lawyers who don't like it.
Interesting.
It's lawyers who give us a really hard time and who, not always, but on the occasions where it's tricky, the reports I get from other journalists are that they're being obstructed. They are having arguments made against them even being in court still, which really worries me. And judges tend to, give that very short shrift. So I sort of struggle to know why, barristers bother anymore, because we are going to be there. At the very least, we're going to be there.
Has it decreased, though, that hostile?
Well, I'm not sure, because it might be that there are more journalists going to court. And so I get messages from them kind of going, how do I deal with this? The barristers are trying to exclude me, or they're they're saying it has to be dealt with at another hearing. And, then you've got so many resources. So it might just be that there's more journalists.
Yeah.
So they're coming up more.
And have you become almost like a leadership journalist then? So are people leaning on you for guidance?
It doesn't feel being much like a leadership journalist in my study, where I'm sort of like literally WhatsApping people, kind of going, try this, try that, say this, say that. Or this is outrageous. It can't be allowed. It's just that I'm more experienced.
Yeah.
That's it. It's just, I've just dealt with more of those situations.
So what's been the uptake then for journalists, and have they got support from their organisations, both in terms of funding and investing the time to really understand a family case? Because as you know, it isn't just a check-in, check-out.
Yeah.
There's a timeline that you've got to commit to.
Yeah, there is. There really is. So a journalist called Conor Gogarty in Wales has done
Twitter,
work over many months now and has followed cases and has, importantly, I think, reported on some, and I say this in inverted commas, ordinary cases, because none of them are ordinary, life-changing cases for those people in the Cardiff Family Court. More recently, another freelance called Charlie Maloney has been just dipping his toe in the water and finding it fascinating, and has written some really interesting pieces for the Daily Mail and the Telegraph. So again, reaching different audiences, because I tend to write Urban and I now work for Tortoise.
Okay.
So I think, yes, to a degree, I know the judiciary were thinking that there would be this flood of journalists, and there hasn't been a flood. But, we ran through the Bureau of Investigative Journalism, which had some funding for this. We ran something called Family Court Reporting Week last year. Late last year. And that was really successful. I went and mentored journalists at court. I went to Manchester. That was really interesting. And as well as Manchester, I came to Liverpool, and you guys hosted an event, and that was, I think, really successful. So there is real support from the legal community, and I would not have got this far without incredible support from barristers and solicitors who have navigated me through the thickets and all the danger I could so easily have fallen into. So thank you.
There you go.
Journalists from that have written stuff. And, I managed to persuade a young trainee journalist at the Times to persuade her editor to give her a week.
Okay.
And she spent a week at Birmingham Family Court and wrote a really interesting piece out of that. So I think it will be incremental and it will be slow, because it is a big time commitment. And I think it's more akin to investigative journalism than it is to news reporting.
Yes. And so if you were to forecast for our listeners what is incoming for 2025, so what's on your agenda, Louise? What are you looking to achieve? What would be the highlights?
I always want to look really deeply into the reasons why decisions have been made. So I'm hoping to do a very deep dive into Sara Sharif. A lot has been reported already, but what I am thinking to do is to try and take listeners into the court setting to see what the judge had in front of her. So they are effectively in the seat of the judge and hearing the evidence that she heard at different stages and thinking what they would do.
Okay.
So that's one of my big projects. And the other ones, I can't tell you about yet.
Oh, well, that's not fair. But I suppose gives me the natural springboard to say you're going to have to come back then and join us for a third podcast at some point in the future when you are ready to share what sounds like an exciting event on your calendar.
I'm very happy to do that, Lisa.
Well, on that note, I'm going to bring this episode to an end. So, Claudia, thank you for joining us.
Thank you.
And Louise, thank you very much. As you know, I've always been a supporter of yours and your passion and drive for shining the spotlight on transparency and helping the family justice system become healthier and more positive for all, and identifying where lessons can be learned and making sure that collectively we all play our part in improving standards. So carry on your good work, because you have people out there that are watching you and supporting you, certainly from the sidelines. So thank you very much for joining us.
Thank you. Bye. In the next episode of Family Law and More, we will be discussing the legal sector and well-being, breaking the silence on stress and mental health. The legal profession is known for its high-pressure environment, long hours and relentless workloads. As part of Stress Awareness Month, this episode will explore the critical importance of well-being in the legal sector, tackling stigma, burnout, and mental health challenges that many barristers and solicitors face. In this episode, our expert panel will discuss the reality of stress and burnout in the legal profession, cultural challenges in the bar, practical strategies for maintaining well-being, what firms, chambers, and organisations can do to improve well-being, and the Bar Council's initiatives and what support they have available for legal professionals.